So as it relates to Cape Marco Property Owners Association Incorporated and its subsidiaries, I'm going to focus first and maybe only on records. Too often, management companies and boards and attorneys basically put in place ridiculous records policies that are contrary to law to limit access to records that are the owner's records. They're not the board's records, they're not the management company's records, they're not the lawyer's records, they're the records of the association where owners have an interest protected in law to be able to inspect and see those records. I'm going to walk through some of the law around records and records access. But then I'm going to look at the Cape Marco Property Owners Association Incorporated record policy, and we'll bookend those together. Just so you know, I am not a lawyer. I am not giving legal advice. I will help people in arbitrations because in Florida, a non-lawyer is allowed to help in arbitrations. I will help people and consult with them on getting access to their records, and that's what I'm going to do in this case as it relates to Cape Marco Property Owners Association Incorporated and its subsidiaries. So what I put up on the screen here is from the division, and it relates to an arbitration, and I think it's a boilerplate thing that they give to people. Frankly, this should be online for everybody. Frankly, the division should have a repository online of all arbitration decisions, as well as a summary of those decisions. In Ohio, there is a thing related to government called the Yellow Book that's online. That's sort of a citizens analysis provided by the Attorney General of what the rules are, and all framed in different case law and decisions that have been made. Owners in Florida need that. Frankly, they probably need that more than just keep changing the law with that completely inept division that can do little to nothing and tries little to nothing to actually enforce the law. So this document is from an arbitration that I won against my association, Sandpiper Key Condominium Association Incorporated, when they were hiding records, which is a normal practice for them. They're still doing it. It's almost unbelievable how many times somebody can. I've beat my own association 5 times in arbitration cases, and they still continue the unethical practices. A lot of times with the support of other owners that I think are blue pilled, if you follow the matrix analogy, and just don't want to have to deal with the fact that you have a board and or you have or have had a management company and legal counsel that's unethical. So let's see what the division gives to you when you're in an arbitration. Frankly, it should be online a lot earlier for all owners, telling you about what the rules and laws are as it relates to record access. I'm going to go to page 2 of this to start with. Records and your access as owners to records is governed by Florida Statute 718-111-12. That enumerates the records, and there's sort of a catch-all of any record used in the operation of the association, and it also governs your ability to inspect records. It says, I highlighted some points here, it says subject to strict construction. Well, what does that mean? So that means it's black and white, sort of like you get pulled over for speeding. If you were going over the speed limit, it's black and white. You are guilty or innocent just based on strict construction. I'm going to hit some of the key points here. It highlights in yellow the provision in the statute does not separate failure to maintain a required record and the failure to provide access to the record. What is this talking about? If your association doesn't maintain a legally required record, that's the same as willfully not providing that record. They can't use it as an excuse that we don't have a legally required record and therefore we're not guilty of hiding a record from you. It says the other highlighted portion, in fact, failure to maintain a record deprives the unit owner of access to that record. Failure to hold a meeting required by the association's bylaws that results in there being no meeting minutes violates Section 12. So if you didn't have a meeting you're legally required to have, and as a result you don't have the record that's the minutes that you're legally required to have, then it's a straight up violation of the records law. You can't use it as an excuse that you didn't hold the meeting. Okay, let's go down here. An association may not shield itself from liability or failure to comply with the statute by laying the blame for noncompliance at the feet of its management company. All right, so they're liable for it. Next highlighted portion, the association may not adopt rules that limit the number of inspections per month or limits the time, hours per month, a unit owner has to inspect records. Let's remember that one. We're going to come back to that when we see the Cape Marco Property Owners Association records policy. they have to let you have access. The requirement of the law is that they have to give you a chance to inspect the records within 10 business days of your record request. So if they don't give you that opportunity, like I had the situation here at the unethical association that I'm part of, where they notified me, I think the office notified me like 15 minutes before the office closed on a Friday, which was the due date. And there was no legitimate opportunity for me to have inspected the records within 10 business days. It's not that they reply to you in 10 business days, it's that they have to have provided you the opportunity to inspect the records within 10 business days. So this one is a parenthetical here is association did not give owner reasonable opportunity to inspect records when it sent owner email that gave owner less than 24 hours notice to inspect the record. An owner is not required to detail each record to be inspected, but may properly request to view all official records. We're going to come back to that when we look at the Cape Marco Property Owners Association, Inc. Records policy. You don't have to be specific a lot of times. You can make general statements like, I just want to inspect all association records. Next highlighted portion I have here. A unit owner is not required to barter with an association as to when it will produce records for inspection or whether all records requested will be produced for inspection. It's not optional. My association tries to pull nonsense where they say, well, we have some records in 10 days, other records we don't have in 10 days. And my association had one of the worst condo, I don't know what's the worst, a terrible condo management company called Castle Management, in my view. And it's like, okay, hold on a second. This company claims to be a great condo management company, but they haven't put processes and procedures in place to be able to comply with the law on records requests. So what does that tell you about that management company? So the bottom part of this page, page 3, gets into the most important thing. All a unit owner must prove is to have a records case and to win a records case. You only have to prove 3 things as an owner. 1, you made a written request. 2, the request was received by the association. And 3, the association failed to produce all requested records for inspection within 10 days of the written request. The association then bears the burden of rebutting the presumption. So there's a presumption in the law that if the association does not provide you the records to be able to inspect them within 10 working days, that they are willfully doing so, intentionally doing so. And so that's the presumption. So if they don't do it, they're on the hook for a willful violation of the records law. They have to rebut the presumption. It's called a burden shift. Basically, since you can't, as the owner, see the records, since they haven't provided them to you, they have to prove that they didn't willfully hide the records from you for whatever reason. They bear that burden. They have to prove that they did not willfully hide the records from you. It's a burden for them, not for you, to prove that they were intentional in hiding records from you. So those are some of the key points that are in this policy or this document that's provided to you when you're in arbitration. They're very simple, very key points about what the law is and what the law means. By the way, you see down here the signature on this is Kevin Butenmuller. Absolutely terrible. The arbitration people, I've dealt with 2 of them. One is decent, pretty good. This guy was absolutely terrible. It's like he worked for association law firms trying to protect them. But ultimately, he ruled that there was a willful violation while despising me the whole time, and because I just drilled so hard on that, what had happened with me in a records request case. But I appreciated this document. Now, Cape Marco Property Association, Property Owners Association, Inc., has these lawyers, Cowan Boyd, Donald Boyd, and Brittany Cowan. I find almost universally, I don't know these guys, I'd be glad to interview them, I'd be glad to talk to them, but condo attorneys are universally not to be trusted. Why? They represent associations. They're beholden to associations. They make money from associations. They're part of the legal club that will protect each other. And now these 2 people are the attorneys, to my understanding, for Cape Marco Property Owners Association Incorporated, Cowan Boyd. Okay, hold themselves out as experts in the condo law. Well, here's what's funny about it. A ton of these attorneys that say they're experts in the condo law don't seem to give a rat's ass about following the condo law. they will gladly allow the board to not follow the condo law and gladly allow them to have policies and procedures that are clearly in violation of the condo law. And I think that these lawyers that do this, and maybe they'll claim that they didn't write this Cape Marco Property Owners Association record policy I'm about to show you, but lawyers that are involved in writing such things should be sanctioned. They should lose their licenses over this until they're held accountable, that they have to have diligence and that the associations they're representing are following the law. Then they're going to continue to play games because it's so hard for owners to challenge their boards and associations. The whole arbitration process is a joke, very difficult. Like I said, I've been through it 5 times and won all 5 times as I record this, but it's very difficult for people to get through it. And there's very little recourse, and the division and the arbiters and the people in the division are either completely terrible at trying to get the law enforced, or they take years to do anything. So let's look at the Cape Marco Property Owners Association Incorporated record policy. So here it is. Okay, Cape Marco Property Owners Association Incorporated record policy. I'm going to go to the second page, and this is the third point. Any request by a member of the association to inspect official records or obtain copies of such records shall be in writing and shall be sent by certified mail to the office of the association's management company. That is not legal. Okay. The only thing that I know of in the law where it actually requires you to send it by a certified mail is an inquiry. Remember what I just read off is you just have to be able to show that they've received it. Hand it to them during a board meeting on camera in a Zoom meeting. That sort of thing. That it is not legal that you have to do it by a certified mail. But this shows you how unethical and immoral condo boards are and their attorneys are. Even if it allowed this in the law, why would you do this to your owners other than you hate them? Other than you just hate your owners that are paying the legal bills these lawyers are getting paid. Why you hate them? Do you hate owners? So they can't stop by the office and drop it off. They can't turn it in during a board meeting. It has to be by certified mail. First off, it's not legal. Second off, it shows the lack of moral and ethical compass of boards that would intentionally put things in their records policy that serve no purpose other than to make it difficult for owners to inspect records. I'm going to skip down to number 5. The written request must specify the particular records requested for the inspection, including pertinent dates and time periods. No, I just read out of the other document. No, you could just request, I want to come in the office and inspect all association records. That would be a legal request. This is illegal. These lawyers, now I've also found that a lot of the lawyers have never been through actual arbitrations, have never been challenged on their nonsense, but they should know the law. They should know what was in the document I just rattled off from you from the division on what some of the case law is. So this is, in my view, this is another illegal part of this policy. So then item 6, okay? So you got 10 business days is in this when they can be expected. And it says the board of directors in its sole discretion or its agent may designate that such inspections take place at another location within 45 miles of the Cape Marco property or within the county where Cape Marco is located. I don't know if this is legal or not. My assumption is it's illegal if you said, like, we're going to drive out to the edge of the county 45 miles away. But it would be another example of a lack of moral and ethical compass that the board in its sole discretion would decide they're not going to let you see association records that are supposed to be where? At the association, unless you drive up to 45 miles away. Who are these people? I mean, are they immoral, unethical people? Do they, it's crazy, some of the things that are in here. And then number 8, member inspections, including each unit owner, spouse, or occupant of the same unit, are limited to a maximum of 1 request within 30 days, 30-day period, for a maximum of 8 hours of inspection time within a 30-day period. I just read from the law that you can't have a limit on the amount of inspection time. You also can't have a limit on the number of requests. It is ridiculous, 1 per 30 day. So let's pretend that you made a request to see some ledger records, and then you wanted to see the detail under them. This association, I guess, because it would be acting in an unethical manner would try to keep stretching you out. No, you got to wait 30 days to be able to see that. You need to wait 30 days to make your next request. It's illegal. This is illegal, and it's unethical. And it's another problem in this Cape Marco Property Owners Association Incorporated records policy. Okay, so let's go to the next page and highlight a couple other points in here. Number 14, if a member desires to obtain a copy of any record, the member shall designate in writing which record is desired, or during inspection, the member may designate such record by use of a tab or clip upon the pages desired. Okay, that's fine. It's not wrong, but you can also just make your own copies. You can take pictures with your phone, and I don't see that shit in here. You could bring a copy machine or a scanner with you. A lot of people, for a couple $100, you could buy a portable scanner that would make it very easy to scan stuff in real time when you're in the office and be significantly less. It's not take that long. You're going to see in here, somewhere in here, they have 25 cents a copy in number 17. You're going to see that eats up real quick, and you could just get a portable scanner or a portable copy machine. I have both a portable, HP makes a portable printer, scanner, copier that's battery powered, and other companies like Brother, Canon, and etc. make a portable scanners. And then you have these things that are arbitrary here. Number 15, no inspection or copying of records shall be conducted in a manner to harass any member, resident, or association agent, officer, director, manager, employee. Okay, now obviously, you don't want people quote unquote harassed, but what does that mean? What does it mean? Okay, Florida's a two-party consent state, meaning you can't record people without their consent. Most states in the country are one-party consent states, which means that you can record a conversation of which you are a part without informing the other members that you are recording. You can't do that in Florida. So it would become in the eye of the beholder, or he said, she said, what was quote unquote harassment. And I hate this. I hate the term harassment as it relates to these things. If you want to use an actual legal term like menacing, menacing would be threatening physical violence, making somebody mentally unstable as a result of kind of the way you're interacting with them. But this is in here basically to have a cop-out way to kick you out of the office, basically, as far as I would assume, because it has no definition as to what harass means. And I don't know how well it would be legally supported that you just have some arbitrary, we said, well, we thought they were harassing us, so we kicked them out of the office. Okay? Let's go to the last page I'm going to hit on. This is about inquiries. Inquiries are a different thing than record inspection requests. Inquiries are your ability to ask for a legal judgment from your association on something related to you and the association, and they have to give you an answer, and they get 30 days to do so. It's in the law. This is the thing that you do legally have to submit an inquiry request via certified mail. It says any member wishing to file a written inquiry shall submit a written request to the association's management office and serve a copy on the association president of the board of directors via certified mail. I don't think that's legit. Okay, I think you follow the statute, which would be that you send a certified copy to the association or a representative of the association that you could justify that you have a record that they've received the inquiry. You don't have to. I don't know where they get that you have to do two different things here. Both do two copies, one to the management office and one to the association president separately. So, any event, that is the Cape Marco record policy. I'm going to dig into this, and frankly, the pathetic division should have kind of sample pro forma model records policies, declaration, bylaws for associations that they could say to help people that the division gave example of. Here's an example of a clean, pure, proper record policy without any illegal stuff in there, like this has multiple illegal things in it. Okay, so that's the deal. And I've referenced Cowan Boyd, the attorneys that I believe did this record policy. And maybe they're wrong. I'm glad to talk with them. Maybe they're just ignorant and don't know condo law. By the way, that's very common that people that say they know condo law don't know condo law. Again, I am not a lawyer. I'm not giving legal advice, but I am speaking up because too many of these lawyers mislead while they're giving legal advice, mislead and support basically illegal policies. And I believe that this policy at Cape Marco Property Owners Association has, what did I hit? Probably at least 3, 4, 5 illegal points within the policy. So make sure that you know your rights. And if you're being abused in the same way in your association, keep following along as I work through Cape Marco Properties Owners Association and some of its subsidiaries issues with records and records production.